In this video, I'm going to be looking at this article, Lucy Letby and the Handover Sheets, that's been written by David James Smith. David James Smith is an author of some repute. He's been a journalist. He's written several articles for The Independent recently on Lucy Letby, which I would say had a quite significantly pro-establishment slant. He's also worked for the CCRC for a few years, and I will discuss that as the video unfolds. I should say as a disclaimer before we begin that I think the perspective of myself and David Smith, or David James Smith as he calls himself, is fundamentally opposed. I think we have a very different view of the world that is almost diametrically opposed. And I don't just relate that to the Lucy Letby case. I think I would relate that to society as a whole and authority. I think our views are just vastly different. With that being said, I think this is an article that's worth assessing because this gentleman has worked for the CCRC for a few years. I will say that his previous articles for The Independent were, I think it's reasonable to say, very much pro-establishment and very much apologetic for the system, or favourable towards the system. I don't think that's an unreasonable characterisation. But without further ado, I will get into this article about the handover sheets. Regular viewers will know the handover sheets are not my favourite aspect of the Lucy Letby case because people fixate on them despite the fact they're nothing to do with the allegations whatsoever and are essentially completely irrelevant. But he has chosen to focus on the handover sheets. He may write on other subjects in the future, we'll see. But I wanted to take a look at this one first. So this is just on a Substack, so I suppose it's a Substack post rather than an article, but I'll start reading through this post or article, and then I will interject with analysis when I deem that to be necessary. Not that long ago, I wrote about the Lucy Letby case for The Independent, reflecting on the content of the Netflix documentary, The Investigation of Lucy Letby. So I've been tempted on a couple of occasions to analyse other articles that he's written, but I haven't done that, usually due to a lack of time, but I thought this would be worthwhile on this occasion. I've kind of summarised the content of his previous articles. He sort of claims to sit on the fence or to not have a view, but I don't really agree with that or believe that, if I'm honest. I think he will always be a system sympathiser, essentially. The film contained clips from Letby's police interviews and, among other things, dealt with the discovery of medical handover sheets during searches of her home in Chester and the home of her parents in Hereford. Some of the handover sheet information contained in the Netflix documentary has since been contested, and so, with welcome assistance from others, I resolved to try and produce a detailed and accurate account of the position in relation to the handover sheets as the evidence of them unfolded at the main trial, which ran for 10 months between October 2022 and August 2023. So, I'm not sure what he's referring to when he says some of the handover sheet information contained in the Netflix documentary has since been contested. They did make this chronological statement that is just plainly incorrect, and he repeats that later in the article. So I'm not sure how much effort he went into in producing a detailed and accurate account of the position, but we'll get onto that later. I'm really a critic of the handover sheets, fundamentally, because, as I say, they're completely unrelated to the allegations, they're completely unrelated to the indictment, they ultimately mean nothing, as any nurse will tell you. Those proceedings concluded with Letby convicted of 7 murders and 7 attempted murders. 2 of the attempts were on the same baby, which has created some confusion about the number of convictions in the first trial, 14 from 13 babies. She received 14 whole life sentences, 1 for each guilty verdict. A 15th whole life sentence was added after her conviction at retrial for a further attempted murder involving a different baby in July 2024. I hope this, gets a bit more interesting later on rather than just telling us that Lucy Letby has been convicted. It is unlikely to have escaped many people's attention that there is a glowing clamour of doubt about the safety of her convictions. It has been generated in part by a PR effort on Letby's behalf involving her post-trial barrister Mark MacDonald in collaboration with Maltin PR, a public relations firm with a legal focus that specialises, among other things, in crisis communications. So he's going to go on to talk about this a bit more. Has a convicted serial killer in England and Wales or any convicted murderer for that matter, ever previously been represented by a PR company? I think not, which, unless I can be corrected, sets an intriguing precedent in the world of reputation management. So, the first thing that I will say about this is that this has already been corrected by Lucy, who has said that, quite rightly, that Sally Clark was represented by a PR company and, of course, exonerated and then very sadly died. So that's the first thing, is that it's not unprecedented. The second thing I will say is that this is just repeating arguments that have been made by other people previously. It's not a particularly insightful comment because other people have already spoken about this. And then the third thing I will say is that the reason that you're represented by a PR company, there are many legitimate reasons for this in this specific situation. So obviously one of them is to raise public awareness. Another one is to not just to raise awareness among the general public, but among the medical profession and other relevant specialisms. And indeed, that has been successful, because at the time that the press conference took place, there were 14 experts and there are now 31 experts. So that's been enormously successful immediately. And then the third thing is, I'm not sure if this has been an issue for David, but I'm certain that the other people that have raised the PR angle, I'm certain that it hasn't been an issue for them, is that sometimes you require PR representation in order to help you in life if you're a successful person or if you're involved in something that requires a lot of work, for want of a better phrase. So I will have a PR company working for me. I have a PR company working for me now on my book, and I'm not going to hide that or pretend that I don't. And the very simple reason for that is because I've been writing the book. It's not finished yet, even though I've handed in a final draft. I'm still amending it. I'm still speaking to people. I'm still doing things. As I'm also doing this YouTube channel, I'm sure you can imagine this channel takes quite a lot of effort. Then on top of that, I get an enormous amount of correspondence now. And then on top of that, I'm constantly doing things behind the scenes, some of which I can discuss, some of which I can't discuss, and doing campaigning stuff. And it's a pretty big workload overall. So I don't think I can reasonably expect it on top of that to deal with all of the media aspect of writing a book of this likely prominence and certainly importance. And, you know, it's quite probable that I'm going to be making public appearances. So if I do that, do I have to arrange all those things myself? And then do I have to arrange the launch event? No, obviously not. It's completely unrealistic. I've already got enough on my plate. So that's why you have a PR company. Most writers, if you look at, as an example, Stephen Fry. Let's think about someone who's very, very famous, Stephen Fry or David Mitchell out of Peep Show, seeing as I like Peep Show. They will have a literary agent, undoubtedly. And I doubt they even wrote a letter to find their literary agent. It will all be done for them. Everything is done for them. When Stephen Fry or David Mitchell write a book, all they do is turn up and say, well, obviously they will actually write the book. In some cases, celebrities don't even write their books, of course. At least they will have probably written their books, although we can't even say that with 100% confidence. But it's likely they've written their books. And all they do is write their book and then turn up. You know, whoever arranges their diary says, right, you've got to be here on this day, make sure you're there, and then they turn up. That's it. That's what happens if you're a successful person or involved in a massive project. And Mark is a full-time professional barrister, and then on top of that, he's doing Lucy Letby's case. So it's hardly realistic to expect him to organise everything to do with the case and organise the press conference and organise everything else. Now, in terms of whether, I know there's been some comments about, oh, it's not the done thing to have a press conference. Fine. Well, if you do the done thing of not having a press conference, then what happens is what happened to Peter Sullivan, where he's in prison for 38 years. It happens to what happens to Andrew Malkinson, where he was in prison for rape for 17 years without being exonerated, and he served an enormously long sentence because he wouldn't say that he was guilty and he wouldn't apologise. And then obviously there's the Birmingham 6, there's the Guildford 4, there's Justin Plummer's just been exonerated, and Jeremy Bamber is still in prison now. He's going to be mentioned later in this article, and he has been in prison for 40 years now. Or if you take the example of Colin Campbell, He had a quiet little appeal. It was nowhere near as big as Lucy Letby, with very similar allegations, and he was just thrown out immediately. Now, I do think his defence made mistakes in the court at the Court of Appeal, but nevertheless, he's still in prison. He's been in prison for a very long time. He's set to be in prison for much longer. Now, I should think that taking the moral high ground and having the approval of this journalist probably is not that important to him. So, obviously, what Mark is doing is bringing a wider awareness of this case and bringing it into the public eye, and that's been very successful, and that is absolutely needed. And I've read this quote out a couple of times that's from a top judge, considered one of the top legal minds of his generation, and he says absolutely public opinion is very important in the criminal justice system. It's only really an elitist view to say that, that the public should, the court should just be left to itself. Everything about the way that the court system operates in this country is elitist because, as I've mentioned previously, it's not recorded. The transcripts are difficult to get. So it all happens behind closed doors. It's all funded by the public, and then when the public are told, you have no right to see what went on. And then when there's any effort to engage the public in court decisions, it's like, oh, well, that's not really playing cricket, is it? That's not the right thing to do. Well, I say it is the right thing to do. But as I say, mainly, the main thing that I would point out is that it's just necessary for Mark to have a PR company in order to have a press conference. But what's he supposed to do? Organise it himself while also doing his full-time job? It's absolutely ridiculous. So let's continue. I think not, which, unless I can be corrected, I've already read that bit. I do recall a PR company circulating among journalists during the honour-killing trials of Shafalia Ahmed's parents at Chester Crown Court in 2012, but I don't think their involvement lobbying on the parents' behalf survived the parents' conviction. There is no suggestion the couple were wrongly convicted. So I'm not sure why he's talking about that. Moulton helped organise the Letby press conference in Westminster in February 2025, at which Dr. Shuley pronounced on behalf of his 14-strong expert panel that it had not found any evidence of murder. Thank you for letting us know. You could, if you chose, contrast that pronouncement with the closing submissions made to the Thirlwell inquiry by lawyers on behalf of family groups 2 and 3, led by Richard Baker KC, which make a detailed and powerful case that Letby was and remains properly convicted. So one day I may go over the whole of this submission. I've been over the statement that was made. These were my very first videos on this channel. It does not make a powerful case. The case is absolutely flawed. I agree that it's detailed, it's lengthy, but it's not a powerful case, and it's not an accurate case. And I noticed that there's no mention here that Mr. Simon Driver is representing the families and also working for the prosecution. That's the thing, that if you seeing as this is a critical article, or supposed to be a critical article, that's the kind of thing that I think you would tend to bring up. But surprisingly, this journalist doesn't bring it up. So he continues. Those two polar opposite positions are irreconcilable. They can't both be right and have led to some hostile debate on X and elsewhere. Yeah, if there are two polar opposite positions, it's true that they both can't be correct. I agree with you there. The campaign on her behalf suggests that those acting for Letby and those supporting her believe that public opinion and media pressure can influence the decisions that will later be made, not only by the Criminal Cases Review Commission, but also the Court of Appeal criminal decision, if or when the CCRC makes a referral. So I'll read the next paragraph before I respond to this. I am quite sure that both institutions have regard to their own reputations, especially the Commission, which remains beleaguered after the damage done by its multiple errors in the case of Andrew Malkinson and the ham-fisted attempts at damage limitation by its previous leadership team, along with other baffling decisions which appear to have been designed to corporatise the CCRC and defeat its core purpose. It now has a far more able and adept chair in Vera Bird and a new chief executive, although both appointments are currently temporary. Whether the CCRC or the CACD will ever allow concerns over their reputations to influence their decisions in this or any other case is hard to know. Let's hope not. The stakes are high, especially so for the Commission, whose very existence was surely threatened by its calamitous recent history. So I would think, David, I'm just going to take a wild stab in the dark here, but I would think that among the general public, there's going to be a very low percentage of people who are concerned about the reputation of the Criminal Cases Review Commission. I think in a case such as this, where a nurse has been very obviously wrongly convicted and there is an innocent person in prison, I'm again going to take a wild stab in the dark and presume that most people will care about whether or not that person is guilty or innocent, and the reputation of the legal system will be a trivial or indeed completely immaterial matter for them. I'm actually surprised that you've put this in your article, if you want to call it an article, because it reveals your inherent bias. You're actually, before you've expressed any concerns about whether or not Lucy Letby is guilty or innocent, you're concerned about the reputation of the Criminal Cases Review Commission for which you worked. And then coincidentally, all the articles I've read of yours, as I say, lean heavily towards being pro-establishment and pro-system. So you'd think you wouldn't show your hand quite so blatantly, but yet you do. I'm not sure why you've done that, but obviously you felt you had to express some concern about the CCRC. And understandably, when people do things in life, this gentleman is obviously proud of the fact that he worked for the CCRC, and it must be very difficult for him to see the fact that the CCRC is almost universally berated by everyone. And it's not just the Andrew Malkinson case. There have been many articles in the press decrying the Criminal Cases Review Commission. In fact, I will just show you some of those articles right now. So there has been a lot of recent criticism of the Criminal Cases Review Commission, and as the author notes, some of that is related to the debacle of Andrew Malkinson, where he had exonerating DNA withheld and served a further 14 years in prison because of that. So in this instance, the chair of the Criminal Case Review Commission offered an unreserved apology. This was Helen Pitcher, and then she made comments when she resigned, and now there's Vera Baird. And I will credit Vera Baird with trying to at least make herself visible, and at least the optics of trying to do something about this organisation have been there. Now, the proof is very much in the pudding, not in the cooking of the pudding. It's not really the appearance that is important, it's whether they actually do what they're supposed to do or not. But at least aesthetically, it seems that there have been some changes. So here's another article, recent one from the Daily Telegraph, and they talk about the speed of the Criminal Case Review Commission and how it's been very slow. They were quite slow in Lucy's case. Now, they would say in their defence, and they have said in their defence, that Mark McDonnell took quite some time to waive privilege, and that is not an entirely unreasonable argument. But this case should be with the Court of Appeal now. It's blindingly obvious that this is an unsafe conviction, let alone that it's safe beyond reasonable doubt. So there's no reason. I mean, someone has asked me the question in a previous video, one of these Q&A sessions that I do, of how long should it take, and I think it should take a month to be able to see this that this is a potentially unsafe conviction. Now, maybe they've been doing reports, who knows what they've been doing, but it has to come soon. It has to come sooner rather than later. So I do agree with this criticism of reluctance to expedite this case. But this author of the article is trying to suggest, the CCRC was fine, and then the Andrew Malkinson happens, and now there's some stuff with Lucy Letby, and that's tainted the image of the commission. That's not a reasonable representation of reality. So you can look back at this article that's 16 years old, and this is fairly critical of the Criminal Cases Review Commission. The numbers show how hard it is for applicants to meet this test. Since 1997, the CCRC has reviewed more than 11,600 cases, only 385 of which it has referred back to the Court of Appeal. As of March 2009, 273 convictions had been quashed as a result. So I often quote this statistic from the Westminster meeting of there being between 2,000 and 10,000 innocent people in prison. So those 11,600 cases are over many years, but that's almost equal to the 10,000 people. So it's managed to exonerate 273 of those people, which is a pretty poor strike rate. It's over 1%. It's less than 2%, isn't it? It's approximately, 1.7%, 1.8%, 1.7%. So it's not an enormous number, clearly. And then this is a very famous article from Bob Woofenden. The Criminal Cases Review Commission has failed. Set up to investigate miscarriages of justice, the CCRC's poor track record in recent years shows it is little more than a fig leaf. This is from a year later. And then he goes on about how the early years it was valuable and productive, but its performance since the start of 2005 is not impressive. In that period, the CCRC has successfully referred 7 major cases to appeal. In fact, this meagre tally overstates the CCRC's performance level. One of these cases was that of Sean Hodgson, whose legal team had the brilliant idea of bypassing the CCRC altogether. They took it straight to the police and prosecution, who discovered that the DNA on the victim's body was not Hodgson's and said the appeal would not be contested. Unfortunately, when that happened in Malkinson's case, Greater Manchester Police covered it up, as has been revealed by The Guardian. So the CCRC was presented with a fait accompli, which did not, of course, prevent it from listing the case as one of its successes. Then he goes on to say another was that of Patrick Nolan. This was a confession made under duress case of the kind that the appeal court has been quashing convictions in for at least 10 years. Any competent body could probably have dealt with it in a couple of months, rather than the more than 5 years it took the CCRC. And then there's another article here, Criminal Cases Review Commission must be reformed, say campaigners. I'm not going to read from this article, as obviously you can see it's got the Birmingham 6. This is going back 13 years. And don't think that it doesn't go back further, because this article from 2001, this is in the BBC. This is when the BBC used to do actual journalism. An interesting article first published by the BBC as part of its Life of Crime series. And this article, interestingly, notes Paddy Hill is quoted here, won the Birmingham 6. Justice is something that is not on this government's curriculum, and he's talking about the adversarial system needing to change, and a continental-style inquisitorial system would be preferable. This is 25 years ago. How little has changed in those 25 years? So this article goes on to talk about backlog, things being held up, and so forth, and I think this is Chris Mullin, the journalist who wrote on the Birmingham 6, admitting that the adversarial system has flaws and saying there is a strong case for a system which finds the truth rather than a contest between skilled adversaries. But you should realise that the continental inquisitorial system had also led to miscarriages of justice, and I won't deny that. I'm not suggesting an inquisitorial system would be perfect. I'm saying it would be preferable for cases such as the Lucy Letby case. So you can see this has been going on in exactly this form, exactly the same themes that are being played out now for at least quarter of a century. So the argument that this rather partial journalist who worked for the CCRC has put forward that, oh, this is just a bit of a storm in the teacup, absolute rubbish, is untenable. So the article continues. During my own tenure as a CCRC commissioner leading a high-profile review in a murder case which was being promoted as a wrongful conviction by a national newspaper campaign, I was always mindful of the potential for adverse publicity. I tried to drive the review forward and maintain momentum, some reviews take years, to forestall criticism over delays, but I certainly would never have allowed that external pressure to influence the decision that was made, not by me alone, but by 3 commissioners sitting in committee to decide whether a referral back to the CACD was justified. It was in that case. So I'm not really sure what this is other than an attempt to defend the CCRC, and particularly yourself when you were working for the CCRC. But I've already given a fairly robust critique of the CCRC, so I won't say anything further at this point. I do not know if Lucy Letby is A, innocent, or B, the victim of miscarriage of justice, but I do believe it will not be as easy to overturn her convictions as a lot of pro-Letby Twitter X posters and others seem to think. So I think this is a fairly weaselly sentence that is written here. Let's just deal with the points one by one. Firstly, no one is under any illusion that it will be easy to overturn the convictions of Lucy Letby. It's a very high-profile case, firstly. Secondly, she's already been in prison for the best part of 6 years. Thirdly, people are not naive. They know how the system works, and they can read any newspaper article, such as the ones that I've just referenced, and see how few convictions are overturned. So the idea that we're all thinking, oh, it's just going to be a complete walkover. That's not true. We know that the Court of Appeal has made many mistakes in the past. We know that the Criminal Cases Review Commission has made many mistakes in the past. What people believe, and rightly so, is that this is a very obvious miscarriage of justice, that Lucy Letby is very obviously innocent, and critically, in this case, there aren't any crimes. At least in the case of something like Jeremy Bamber, that someone is dead. At least in the case of Andrew Malkinson, someone was very unfortunately raped. So both of those things are tragic. That there is a tragedy at the heart of the Lucy Letby case in that infants have lost their lives, but there are no crimes that have been committed at the County Chester Hospital. So that's why people feel strongly about it. It is wrong, is absolutely inaccurate, in my opinion, certainly. And I can only speak for myself, I suppose, but I think I can broadly represent the community. I don't think anyone is under any illusions or believing it's going to be really easy to overturn a conviction. We're still waiting for the CCRC to make a decision. So I think that's a kind of rather underhand misrepresentation of our position. The second thing is, we're not pro-Letby, as you describe it. I don't know Lucy Letby. I've never communicated with Lucy Letby. I don't know if I ever will communicate with Lucy Letby. I've not communicated with her parents. Obviously, I feel a great deal of sympathy for her, and as much as it's possible for me to empathise with her predicament and her circumstances, I do empathise. I don't think anyone properly can, unless they've been through similar circumstances. I guess that I've now spoken to Tom Hayes, I've now spoken to Michael O'Brien, and I've spoken to a couple of other people who have involved in similar situations, and I guess that has slightly enhanced the amount of empathy I have, but I don't know what Lucy's going through. It's impossible for me to know. But I'm not pro-Lucy Letby, I'm pro-justice. This is not about Lucy Letby. Obviously, her circumstances are awful, and I hope she can be exonerated as soon as possible. But when she is exonerated, which I believe is inevitable, that's not the end of this. This is just the beginning. This has revealed massive problems in the healthcare system, in the criminal justice system, in the police, with the way that these cases are investigated. And that is what people are concerned about. They're not some sort of lobby or fan club for Lucy Letby. We don't know her. We've never met her. And to describe us as pro-Letby is, I think, pretty despicable, really, when, as I say, what we are ultimately is pro-justice. I could just as well say about you, the author of this article, that you're pro-establishment, and I'm sure that you would reject that, and I'm sure that you would object to that description. I think that would be, personally, I think it would be an entirely accurate description. But I'm sure you would say that you try to be as objective as possible in your articles. So I won't characterise you that way. And I think it's pretty unforgivable for you to characterise us in the way that you just have. And finally, to suggest that the opposition to her convictions is based on Twitter/X posters, which, by the way, he posts on Twitter as well, is a deeply unfair misrepresentation given the calibre of expertise. And I know he's mentioned some of those experts already, but a lot of the people posting on Twitter as well are doctors, are professors, are medics, are nurses, are statisticians, are people with credentials, people with more credentials than this gentleman who is just a journalist, has no medical understanding whatsoever. So I think that to emphasise or to place an emphasis on the idea that the people that are talking about this are just people posting on Twitter is, I just think it's a quite deliberate misrepresentation of the situation that is difficult to defend, frankly. So then he goes on, the hurdles are high and many, we know. Not least the fact of her convictions, yeah, we know about that. A jury heard all the evidence and reached its verdicts, yeah, we know. Convictions can of course be quashed, but that is not meant to be. What does that mean? And indeed, it's not an easy process. So, I mean, I would argue against that notion that conviction is not meant for convictions to be quashed. Of course, convictions are supposed to be safe, but the whole basis for an appeal system is that you recognise unsafe convictions and then overturn them. In my estimation, we shouldn't be making this statement that it's not meant to be for convictions to be quashed. That again shows a kind of intrinsic bias towards trusting the system, and that once the system has spoken, things shouldn't be overturned. I don't see it that way, and that's why I said at the start of the video That's why we're absolutely, I would say, polemically opposed, really, in our view of the world, in our view of authority, in our view of how much the establishment and how much the authorities can be trusted. I just don't think our views are compatible in any way. I hope here in Notes on Crime to try and bring some clarity, reliable information, informed comment to this case and others. Well, I hope that you do. As in many murder convictions, the prosecution case against Letby was short on direct evidence and instead was supported by multiple strands of circumstantial evidence, which included aspects of Letby's conduct at the time and subsequent to the deaths and collapses of the baby she was alleged to have harmed. So firstly, in other murder cases, there is much stronger circumstantial evidence. I accept that in most murder convictions, someone doesn't literally witness the murder. That's not in doubt. But I've mentioned the case of Gacy previously, John Wayne Gacy, in which someone found, I think it was nearly 40. It was either nearly 30 or nearly 40, but I have a feeling it was nearly 40 dead bodies in his house. So that was circumstantial evidence because no one saw him kill those people, but obviously it's not looking great for him once they found 40 dead bodies in his crawl space. So there are different calibre of circumstantial evidence. The point here is that the anecdotal or circumstantial evidence is incredibly weak and the medical evidence is fundamentally flawed. It was for the jury to listen to the cases put by the prosecution and the defence, to take account of the judge's guidance on the law and assess the evidence of Letby's behaviour, such as her lies. Incredible that he's saying this, but I'll continue. Her proximity to the events, the way she inserted herself into the grief of some of the victims' families, her online searches for some of them, her handwritten notes of brutal self-reflection, and her hoarding of confidential hospital papers. So I was promised at some point that this guy was going to start engaging in analysis, not just repeat the prosecution case back to us and explain what a court is and explain what a jury is, but I'm sure there's going to be some analysis coming soon. As for your assertion that Lucy Letby lied, there is no proof that Lucy Letby has lied about anything. No proof whatsoever. The supposed lies were incredibly trivial anyway. I've found more lies from the prosecution, outright lies. In terms of fabrication from the prosecution, there's an enormous amount, because so much of it is fabricated, because they make all these assertions for which they have no evidence. So I think to focus on the supposed lies of Lucy Letby when you couldn't actually identify a meaningful lie is pretty despicable, actually. The uncontested evidence in the main trial was that Letby had retained 257 handover sheets. They were found in a variety of places. So he accepts that these handover sheets were found in a variety of places. We'll come back to that later on. An Ibiza bag for life was found under Letby's bed, and this contained various documents, Letby's NHS name badge, and 4 handover sheets relating to babies she was accused of attacking. In a Morrison's bag for life, also under her bed, there were 31 handover sheets, and 17 of them related to babies on the indictment. That meant she had kept a total of 21 out of 257 sheets relating to the babies featured in the case. Only 4 of the babies on the indictment did not feature in any of the sheets. Further papers were found in a bin bag in her garage. So I just want to... I've spoken about all this previously. Something that I was discussing with someone today is the fact that we don't really know where all the sheets were found. Because there were a certain number found in a bag for a life, there were a certain number found in bin bags in the garage, and there were 5 found in this keep box that has been referenced in the Netflix documentary. So that's a pretty small number, the 257. So where were these sheets exactly? It would be interesting to know if we could ever see the 257 sheets. You know, we're accepting the police's word that there were 257, and I'm not saying that's untrue, but we don't know, and we haven't been told where they were found. So I just thought it was an interesting point that was discussed earlier today. The court was shown sheets related to significant incident dates in June 2016. Others included handwritten notes and observations made by Letby about babies she was accused of harming. A packaging box for a shredder found in her bedroom at her parents' home, marked Keep, contained 5 further sheets which were not directly related to the charges. In the Netflix documentary Sequences dealing with the arrests and interviews, it is said that some of the papers were found in date order, implying some deliberate filing by Letby relating to papers in the Keep box, but that claim does not appear to have been made again throughout the trial. So that is essentially correct. However, in the Netflix documentary, they do not say that some of the papers were found in date order. They imply that all of them were found in chronological order. they also imply that the vast majority, or indeed all of the papers, because they don't say otherwise, were kept in the keep box when it was in fact 5 papers that were kept in the keep box. So if those papers were in chronological order, then it means 252 papers were not kept in chronological order. As I've mentioned previously, even though they're definitely not chronological, I've already exploded this myth numerous times, leaving that issue aside, even if they were in chronological order, what does that mean anyway? It doesn't mean anything. If anything, would indicate that they were taken home chronologically, which of course is exactly what you would expect, seeing as they went home inadvertently in Lucy's pocket. But it's not even a reliable form of evidence to say they're chronological, because they're absolutely not. How can they be when some are found in one place, some of them are found in another place, some of them are found in the third place, some of them are found in the fourth? There's no chance they're chronological. And it's not true that they said some of the papers were found in date order. They absolutely said in Netflix they were in chronological order. Not that it matters, because the chronological aspect of them doesn't matter, and even the handover sheets don't matter, because they're nothing to do with the allegations. Nothing. They're completely unrelated to the allegations. Let's emphasise that once more. I just want to return to this point briefly as well, because there's something that I forgot to say. So here he's saying, it's not going to be easy to overturn these convictions, but then he's also criticising Mark MacDonald for running a press campaign, or having a press conference and having a PR agency. He's saying, you shouldn't do that, you shouldn't raise awareness and so forth. But then he's saying, but it'll be really difficult to overturn these convictions. So you can't have it both ways. You can't say, it's going to be really difficult for Lucy Letby to overturn her convictions, but she shouldn't do anything about it. She should just accept the situation meekly and put in a quiet application and then allow the system to reject it. That's why. It's because it's difficult to overturn them. That's why there's a PR company. That's why there's a press conference. That's why he's trying to raise public awareness. Precisely because of what you're saying here, and what the writer continues to say later in the article, indeed. So the article continues. She is seen in the film telling police in an interview that she did not dispose of the sheets because she did not have a shredder. The film then reveals a photograph of a shredder found during searches of her home, as well and I think it should say as well as the image of the keep box it apparently came in. The shredder had actually been in use, but the shredded fragments were of bank statements. Can you believe we're going over this again? But yes, we're going over the shredder again. So, if you wanted to be incredibly critical of Lucy Letby, this is possibly the only thing that she lied about. I don't think for one second that she did lie about this. I think it's far more likely that she forgot that she had a shredder. However, obviously you will have heard me say this previously if you've watched a lot of my videos, but both the police and the prosecution said this in court, and the police said it during the Netflix documentary. They both said Lucy could have used the shredder to have shredded all of the anecdotal evidence. Then this article would never exist, because the handover sheets wouldn't exist, and the confession note wouldn't exist, the so-called confession note. It's actually, in a way, to her credit that she did have a shredder, and she didn't shred this supposed evidence. But that really points to the insignificance of this evidence that we're discussing, because if Lucy Letby had considered it to be significant, she could have just shredded it, as indeed the police said, as indeed the prosecution said. But it seems to have escaped this particular author. Letby admitted at trial that she had recently bought a shredder, but she denied trying to hide the fact and denied that she deliberately kept the handover sheets. She said she used the Morrisons and Ibiza bags to take her uniform to work, and the sheets had simply come home in the pockets of her uniform inadvertently. She accepted it was not normal practice to keep hold of the sheets, and that she should have destroyed them in the confidential waste at work. She also agreed it was her responsibility as a medical professional to keep the information on them confidential. In his cross-examination of Lucy Letby, the prosecutor, Nick Johnson KC, claimed that she had taken sheets with her as she moved homes and had not been bothered about keeping them private. So I've already responded to all of these things multiple times. It's obviously overwhelmingly likely that Lucy is telling the truth, and that these sheets did come home inadvertently, because when she was asked about this by the police, we know this from the police interviews, she's nonplussed at first when they're talking about medical documents. She doesn't even know that they've got any, that she has any in her house. And then she says, oh, well, I might have taken some handover sheets home. She's obviously stuffed them away. I don't know how many more times I'm going to have to say this, but, she didn't want to take them back to work because she knew they were a little bit confidential. She didn't have the time to shred them, so she just put them away somewhere private and doesn't want anyone to look at them. The idea that this notion she's not bothered about keeping them private, she obviously is. But as I've said numerous times, if it was me, I probably would have chucked them in the bin because no one would be any the wiser. They're in a bin bag. You can wrap them up with other stuff. Then they'll go in a dustbin lorry. Obviously compacts them and crushes them, and then they would go into a landfill, and then they would never be seen again. Like the guy who supposedly had £57 million of Bitcoin on a hard drive, and he's thrown it onto a landfill, and now he wants the right to excavate the site so he can try and find his £57 million, and the council won't let him. That's never been seen again, has it? It's not like someone was going to dig them up and, oh my God, look at this private patient information from 12 years ago. It's just not going to happen. So she could have chucked them all out if she wanted to, but she's too conscientious for that. I probably would have thrown them away if it was me. But I mean, maybe I wouldn't. Maybe, if I worked in a hospital, I'd have a different attitude and I'd think, well, really, I shouldn't throw these away. But I'm pretty sure I wouldn't have gone through 257 sheets, shredding them all. But to say that she wasn't bothered about them being private is, again, just untenable. So next, the author goes on to say the following. I want to remind readers here that defendants do not always tell the truth in trial evidence, even though they are on oath, or in police interviews, even though they are under caution. You don't say. It is the prosecutor's job to probe the defendant's account and expose or highlight potential lies. The prosecutor has a case to prove. That's their job, and cases should be as skilled as they come at what they do. They are not there to mollycoddle the defendant, although there may be times when that is a useful tactic. As any judge in any trial always tells the jury, they are the judges of facts. It is for the jury to decide what the truth is and whether the defendant is giving a truthful account. I'm assuming that the author is going to make an actual point in this post at some point rather than just telling us what a court is and what happens in a court. So then there's quite a lot of reading here about the handover sheets. There's a certain amount of... I suppose I'll read through this. I've probably read through it before, in fact I have. Lucy Letby, it's not that I'm not bothered. I know they are at my home address, but they are still held in confidence. Held in confidence in a bin bag in your garage? I am the only one who lives at that property, so yes. What about the ones at your parents' home? Who lives there? My parents, but they don't enter my room. They are not held in confidence? I don't believe anybody would have looked at them. Johnson suggested she only obeyed the rules when it suited her. You like telling people what to do, but you don't live up to those standards yourself. No, she disagreed. The prosecutor continued to press her about the handover sheets. Why don't you want to tell the truth? That is the truth. They have no meaning to me at all. They're just pieces of paper to me. I didn't know I had handover sheets. They weren't significant. So that is very obviously true. It's just so obviously true. And what is actually being discussed here is not whether or not Lucy Letby has murdered babies. It's whether or not Lucy Letby is a good or bad nurse, which is irrelevant. All the evidence points to the fact that she's a good nurse. This may be something an oversight. This may be something she can be criticised for. I don't care, really, because it's not of any relevance. I only care about whether or not she's guilty of murdering babies. Obviously, she isn't. But this whole discussion is essentially completely irrelevant to that rather pressing issue. Why don't you want to tell the... Oh, sorry, he goes on. They were in your work bag. Then this. Are you really asking the jury to accept that pieces of paper with sensitive information on them about their children were insignificant? Yes. So, as we now know, the author doesn't seem to have bothered to find this out, but if he'd spoken to nurses, he would know. Many, many nurses have these sheets in their houses. They've taken them home inadvertently. They haven't thrown them away because they know, I shouldn't really throw this away. They are somewhat confidential. They're not medical documents, but they are somewhat confidential. So they remain in their houses. Now, I'm willing to accept that 257 is a relatively large number, but it can happen that at the end of your shift, it's in your pocket, you forget about it, you don't put it in confidential ways, you take it home, and this repeats. Bear in mind that this goes back to 2010. 2010. So Lucy may have had, let's say, approximately 1,500 working days during that period. So we're talking about maybe 20% of days she accidentally took one home, and 80% of days she didn't. Suddenly, it doesn't look that implausible, does it? It looks quite feasible. Anyway, I can't believe I'm discussing this yet again, so let's just continue. He then produced one of the sheets and asked her to pick it up, asking how it was different to all the others that had been found. He said it was because it had no fold in it. She asked if it was the original. He said it was. You've not been prepared to tell the truth about these handover sheets, have you? The truth is what I've told you. Letby denied keeping the sheets as souvenirs, but the uncreased sheet, i.e. had not been folded into a uniform pocket, turned out to be dated June the 1st, 2010, which reportedly marked her first day of work as a student nurse at the hospital's neonatal unit. She again insisted she wasn't lying about the reason she had kept the sheets. They have no meaning to me at all. I have copious pieces of paper and cards that I have not thrown away my whole life. So obviously, as you know, I've been through this many times before. I've been through the fact that they've tried to use this treasuring and trophies argument. I've been through the fact that she only had one sheet that was kept in this box with a rose, apparently, from 2010. Obviously, it's nothing to do with the indictment. It's 5 years before the indictment. It's from the very first shift she ever did. This is not incriminating. It doesn't mean anything. Obviously, I've been through this previously. Among the documents in the Morrison's bag for life was a paper towel. So we're getting to the paper towel now as well, with handwritten notes for resuscitation of one of the babies in the trial and a printout of a blood gas reading for another baby that she was accused of attempting to murder. The prosecutor reminded her that the nursing colleague who conducted the blood gas test had told the court she would, she would have disposed of the printout, because obviously this nurse can't remember doing that because it's completely insignificant in the confidential waste bin. When did you fish it out of the bin? I never fished anything out of the confidential bin. She said she could not recall how she came by the printout. It was for your little collection, wasn't it, Lucy Letby? No. So now the author goes on to say, the Court of Appeal later picked up on the issue when refusing Letby leave to appeal for the first 14 of her 15 convictions. Incidentally, many people appear to believe that refusal of leave means Letby has not had an appeal, but for the purposes of the appeal process, an application for leave, even if refused, is taken to be a completed appeal, and in this case, leave was considered over a 3-day hearing in late April 2024, as a full appeal might be. Very often, the leave application and the full hearing are heard together, and although that did not happen here, she certainly had a good opportunity to make her case. So I'm wondering if you're going to make any actual points or just tell us about the Court of Appeal now as well. The appeal judgment handed down in July 2024 put the handover sheets in the context of the prosecution's case against Letby, stating that the prosecution maintained that the applicant's responsibility for the deaths and sudden collapses of the babies could be inferred from a raft of circumstantial evidence. So now he's going to go through the circumstantial case. The applicant alone was present on the unit at the time of all of the deteriorations and deaths and was the common factor in all of these cases. Of course, we know by now that this is completely untrue. She appeared to be fixated with being involved in events in the intensive care nursery and involved herself unnecessarily with babies who had been designated to other nurses. So I would say more accurately, what is the case is that Lucy was keen to assist with babies that were vulnerable and that were in the nursery that is designated for this purpose. It is necessary to assist sometimes on a unit in which, yes, babies have been designated to other nurses, but the fact that she wanted to assist with them at times is not indicative of guilt. It's indicative of the fact that she recognised that they required care. It's her lending a helping hand where it is needed. If she has been assigned a baby that is not in desperate need of immediate care and there is a crisis situation, it's absolutely correct for her to help out. And when you speak to nurses, they say, without exception in my experience, that Lucy's conduct was in no way inappropriate. She created, it was alleged, false entries on certain documents to hide her activities, to provide her with an alibi or lay the ground for invented explanations. So I wonder if David is going to examine this in later articles, because if he does, he'll find out that there's absolutely no evidence for any of this. This is a complete fabrication. She retained and took home a large number of handover sheets as trophies of her crimes. These handover sheets were confidential documents and should not have been removed from the unit. Over 200 were found hidden under the applicant's bed. My emphasis he says. After the collapse or death, she searched for the names of some of the babies on the indictment and searched out their families on Facebook. Of course, I've dealt with that countless times. 99% of her searches had nothing to do with the court case. Various handwritten notes were found at her home. One of those notes concluded with the words, "I am evil, I did this." The prosecution relied upon this as evidence, as amounting to a confession. Of course, it's farcical that this has occurred. I believe we've established this by now. Over a 58-page decision, the appeal also endorsed the role of the prosecution's lead expert, Dr. Dewi Evans, which obviously gives the appeal a great deal of credibility, and rejected the submission of Letby's barrister. She was still at this stage represented by trial counsel Ben Myers KC, that Dr. Evans' trial evidence should have been disregarded. The appeal judges said it was unarguably the case that Dr. Evans was suitably qualified, or to put it another way, it is not arguable that he lacked the necessary expertise to give evidence. No one disputes the Court of Appeal did this, but Dr. Evans would not be a great person to have in the Court of Appeal now, I would suggest. The appeal also heard the live evidence by video link from Canada of Dr. Shu Lee, who has since assumed great prominence in the case with his unchallenged assertion at the unusual Letby press conference in February 2025 and in subsequent media interviews in the Sun newspaper and elsewhere that his expert panel did not find any evidence of murder. Dr. Lee's appearance at the Court of Appeal 10 months before the press conference to elaborate on the fresh evidence he might give was not such an easy ride. The court concluded that his proposed fresh evidence was irrelevant and inadmissible. So we know all of this already. I'm not going to comment on this any further. All I will say is that all of this shows an incredible regard for the Court of Appeal, but perhaps not a surprising regard considering what we know about this gentleman's employment history. Of course, such evidence should be relevant and admissible, and it would be fairly extraordinary if the weight of neonatal expertise and evidence that has now been put forward to the Criminal Cases Review Commission is deemed irrelevant and inadmissible in this latest appeal. But let's continue. The appeal court's endorsement of Dr. Evans and its rejection of Dr. Lee are no small obstacles to Letby's further process in her attempts to win a new appeal with her new barrister, Mark MacDonald. So it would be utterly incredible if the CCRC now said, we think Dr. Evans is credible and we think Dr. Lee is not credible, even though Dr. Evans has used the work of Dr. Lee and Dr. Lee has said he's used his work incorrectly. That's even if we didn't know anything about Dr. Evans, that we obviously do. Now, if there was any analysis in this article at all, there's barely no analysis so far, even though we're being promised that there'll be analysis. Surely he would have mentioned the laundry list, Dead Sea Scrolls, indeed, of problems with Dr. Evans and the fact that Dr. Lee is one of the most esteemed neonatal experts in the world. You think that'd be the kind of thing that would sneak into the article at some point, but instead he just repeats the previous appeal court verdict. The case is now at the Criminal Cases Review Commission, where I served a term of office as a commissioner between 2013 to 2018, and is likely to be there for some time to come while the CCRC evaluates all the new material that has been submitted and makes its own inquiries. Then the CCRC will make its decision. A single commissioner could reject it, but it is more likely the case will go through to a case committee where 3 commissioners will sit to determine whether the application meets the CCRC statutory test for referral, see Criminal Appeal Act 1995, on the basis that there is a real possibility the convictions will not be upheld. They may not make a decision straight away. They could decide they need more information to help them, and I would only say that a decision to refer may be possible, but is not a foregone conclusion. So I'm going to summarise the article in a second, but firstly, David James Smith previously met Jeremy Bamber and wrote on this in August 2024, and he concludes this article by saying the following. I remember the interview mainly for the surreal moment after a couple of hours when we stopped for lunch, and 2 or 3 prison officers, my minder from the Ministry of Justice, Bamber, and I sat together and ate from a tray of rolls and sandwiches provided by the prison, making small talk for a few minutes before the interview resumed. He was easy to chat with, charming, present, and with no trace of the psychopath one might imagine to be lurking just beneath the surface. I just couldn't make him out, or his case. Perhaps one day the question of his guilt will be tested again in court, but not, I think, quite yet. So, as a disclaimer, I want to say I don't know anything about Jeremy Bamber's case. I therefore don't have an opinion on whether he's innocent or otherwise. I know many other people do. But Jeremy Bamber was incarcerated in 1986. When he went to prison, he was 25 years old. He's now 65 years old. So the attitude that he demonstrates here of, I can't work him out quite, and I can't quite work his case out, maybe he deserves not to have a retrial, but, there's no hurry. He's had his entire adult life taken away. Been in prison for 40 years, and I certainly know people who believe he's innocent. I really can't comment on that. But it's like this slightly complacent attitude of, oh, well, the system hasn't decided that it should be retried yet, so that's perfectly fine. It's almost pointless to retry it now. He's been in prison for 40 years. You might as well not retry it at all. But if it's going to happen, it needs to be pretty soon, don't you think? And I think this kind of complacent... I'm sure David James Smith would say, I'm not a system-serving person. I haven't said Lucy Letby is guilty, and so forth. But his tone is always leaning towards belief in the system and belief in the correctness of the system, I would argue. And of course, as I've already indicated, that's not a position that I share. So the article repeats the prosecution case and Court of Appeal verdict quite a lot, with relatively minimal analysis, implying, in my view, that once the court has spoken, that should somehow be seen as sacrosanct. The article, I should mention as well, does actually express this sentiment sometimes, saying that once there's been a conviction, it's not desirable for it to be overturned, and that shouldn't happen, which is not a sentiment I can get behind. The article tells us that it will be really difficult for Lucy Letby to overturn her conviction, but then also tells us that Mark MacDonald is in the wrong for doing something to give Lucy a better chance. There is an incorrect assertion about PR companies which Lucy has already disproved. I would contest some of the assertions made about the handover sheet in this article, which are incorrect. It is not entirely clear why the handover sheets should be deemed evidentially legitimate in a conviction of murder. Smith makes no effort to explain why they should be. He simply argues the court said they are, so therefore they are. I would strongly object to the tone and substance of comments made about pro-Letby individuals who believe that this is a miscarriage of justice. Comments here appear to be a deliberately unfair characterisation. Attempts to characterise the CCRC as an organisation which recently stumbled due to the Andrew Malkinson case are not really tenable, as revealed by even a modicum of research. Above all else, the author doesn't appear to have any interest in whether or not Lucy Letby is innocent and whether or not crimes happened at the Council Chester Hospital. Indeed, the only time he does express an explicit opinion on something, it is hoping that the image of the CCRC is not damaged by this affair. He expresses no such concerns about justice or Lucy Letby. So that is my analysis of this article. I thought it would be worth going over, seeing as it is written by this CCRC commissioner. And I know some people have commented a few times that I should work for the CCRC in the future, but I think on the evidence of this article, it's not a role that I would be particularly suited to. With that being said, I hope you've enjoyed this video. I just want to mention that I've been a little bit unwell this month due to allergies, and I've also been doing some work on my book, so I haven't been able to organise the number of interviews that I usually would, but I've been speaking with a few people, and I hope that there's going to be some soon. With that being said, if you have any comments or queries or observations about this video, please let me know.